Welcome, students, faculty, and community to another iteration of A+D Mondays, our weekly program that features the people and ideas, the movements and practices that most compel the Berkeley faculty, students, and staff. My name is Shannon Jackson. I am the Associate Vice Chancellor for the Arts plus Design, and it is my privilege to welcome you here again tonight and to encourage you to join us every Monday night. Many of you know that this series is usually hosted inside the beautiful theater of BAM PFA. Many of you also know that this lecture series corresponds to and is part of a course that I have the privilege to guide, Humanities 20. Welcome, students, tonight as well. And I wanted to tell you now that for this particular event, we're going to ask you to turn your video off. Third, many of you also know that this series is co-curated by a range of campus organizations. If you've tuned into us thus far, you've seen two events thus far hosted by campus organizations like the Department of Art Practice, the Berkeley Center for New Media, and the African American Student Development Office. If you continue with us throughout the semester, you'll see more hosted speakers from organizations like Cal Performances, the Berkeley School of Journalism, from the College of Environmental Design, and more. Tonight, however, we're particularly privileged to welcome a collaboration with two different campus organizations, the Department of Theater, Dance, and Performance Studies, which also happens to be one of my home departments, as well as the Arts and Innovation Advocates, a new student group founded inside the School of Berkeley Law. Indeed, as far as I know, that the Arts and Innovation Advocates is the latest, the newest student group to be added to Berkeley's creative landscape, a landscape that makes a habit of cross-pollinating, of radical cross-pollination across the arts and design, across every domain of scientific and social scientific inquiry. So it is such a pleasure to know that we now have a foothold at Berkeley Law. So to those students who had the vision to found this organization, hello, welcome, and thank you. Thank you for joining a wider network of organizations and people who care about mobilizing creativity for the public good. Before I proceed further, I want to acknowledge, however, a central public good with a volatile history. I want to acknowledge the land on which UC Berkeley stands, and hence the land on which this gathering stands, even if we do so virtually tonight. UC Berkeley is sited on the ancestral and unceded land of the Ohlone people. In acknowledging that history, we recognize not only the deep history of the Ohlone people, but also that the Ohlone people are flourishing, active members of the Berkeley community and of the wider Bay Area community. Many of us gathered for this lecture series and for Humanities 20 feel Berkeley to be a special place, but we also know that we are not the first to recognize, to settle, and to celebrate this exceptional place that we have the privilege of calling our campus. In fact, A+D Mondays, this series, over the last 4 years has been organized around themes that resonate with this topic of the issues of aesthetics and politics of place. Past series have focused on the nature of assembly and reassembly. They focused on fact and fiction, and also on issues of democracy and equity. All of those issues and more are all the more resonant for us now, gathered in fall of 2020, as three pandemics, as physiological pandemics, environmental pandemics, and political pandemics collide in order to challenge our ideas about the boundary between fact and fiction. A collision that is also forcing us to rethink our protocols of proximate assembly. And it is also, of course, a collision that is exposing a 4 centuries long history of undemocratic practice and injustice that now undergirds racist structures and unequal access to opportunity. Those histories are volatile and fraught ones on which to gather, but it is, in fact, the politics and aesthetics of gathering as such that is guiding our series and will guide our conversation tonight. As I hope you saw from online announcements, this series in broad terms is titled Together, Reinventing Politics, Reimagining Health. And we chose that theme in order to galvanize a shared conversation across our campus for our community and for kindred spirits who tune into us internationally. What does it mean, indeed, to gather together, even now, as we gather together online? What do answers to that question have to do with other necessary forms of activist and protest gathering now? Moreover, how have the arts propelled new models for reimagining gathering as such, including activating affects of empathy, as well as processes around criticality that I know are going to be discussed tonight. I'm ever grateful for the A+D team that helps me and all of our colleagues put together this series, especially Paris Coates, Suman Suh, Summer Mason, and Casey Forcier. I'm also particularly glad tonight to have the collaboration of TDPS and of Berkeley Law, and especially of TDPS staff, Jean-Paul Gressier, as well as Ben Dillon, and also to have collaboration with Sarang Shah, who will be moderating tonight's dialogue. You've seen the title for tonight's event, and Sarang is going to say more: How to Be a Person, a conversation on empathy, law, and creativity amid chaos. Before passing the screen to Sarang, let me just tell you a little bit more about him. Sarang Shah is a third year at Berkeley Law, and as a law student, he focuses on law and political economy, on anti-monopoly and economic justice, and on serving the arts community. Recently, he served as a fellow for the Open Markets Institute in Washington, D.C., and also as an intern in the mediation practices for the California Lawyers for the Arts in Berkeley, an organization that many of us in the arts and Bay Area know is a vital and essential and necessary one in our Bay Area arts ecology. Before law school, Shah worked across Europe and the United States as a theoretical physicist, a political activist, a journalist, a tech writer, an amateur playwright, and an actor. In that order, he says. But I think we're going to be asking him to elevate the skills of those latter two roles, actor and playwright, tonight, as he guides tonight's discussion. Without further ado, welcome to A+D Mondays, and even if you're muted, even if your video is off, help me offer a warm welcome to Sarang Shah.
Thank you so much, Shannon, and thank you to the Berkeley Arts and Design Initiative. I can hear the roar of applause in the background that I presume is there, and so I want to thank everyone for coming to this wonderful panel this Monday night. I really appreciate it. So welcome to our event on how to be a person, a conversation on empathy, law, and creativity amid the chaos. Before we kind of dive into I think what you all are really here for, which is our wonderful panelists, allow me to introduce a couple of things. First off, I'd like to highlight the organization that I'm a part of and that I'm very grateful for at Berkeley Law, the Arts and Innovation Advocates. Arts and Innovation Advocates, or AIA, is a newly founded student organization at Berkeley Law, born out of a desire to connect with other creative and artistic students at the law school and engage in meaningful discussions on the role of law in art and vice versa. This is indeed possible, so don't just scoff at it, because we think there's a really meaningful connection there. And so that's why we seek to provide our members, which are students with creative backgrounds and others without such a background but interest in the arts, a community with which they can grow and debate as creative, like-minded lawyers through events and gatherings, such as this one, revolving around the complex and varied ways that art and law intersect. So that actually brings me, I think, squarely to what the theme of the panel is tonight, which is whether there is a useful, constructive, fruitful intersection between art and law, especially in the time that we live in now. So oftentimes, we often ask, why is art and not law so often associated with feeling and empathy? For many, art seems to be connected with creativity, expression, and experimentation. And law, on the other hand, is, to be honest, rather boring, connected with adherence and precedent, rigidity and structure. But are these two practices really so divergent? And can they inform and improve upon each other? If artists at their best are boundless in their exploration, what would a lawyer's studio practice look like? And what possibilities might emerge out of that? So today, our panelists will not only define and contest these categories as artists and lawyers are wont to do, but they'll also consider these questions in the context of a pandemic, a racial reckoning, and a society in need of empathy in abundance. So let me talk to you a little bit about specific details on how this is going to go. So what I'm going to do first is I'm going to introduce our wonderful and distinguished panelists. Following that, the panelists will offer some brief remarks on the theme of the night. We'll, after that, dive immediately into a discussion among the panelists on the theme, going wherever the spirit leads us. And then at around 7:30, so I would say about 50 minutes, 60 minutes from now, we'll start to field questions from the Q&A and end at around 8 o'clock. So this is my reminder for all of you out there in Radio Land tonight that feel free to use the chat function on Zoom for thoughts and comments. Feel free to even say hello or introduce yourselves. This is a community event after all. And then please use the Q&A function for questions that you wish the panelists to address directly. And don't worry about all this. I will remind you later so you don't have to take notes on how to make all this stuff work. So without further ado, I would like to invite the panelists to turn their videos on as I introduce them. And then after that, I'll turn it over to the panelists to offer some brief introductory remarks on the theme itself. So first, the introductions. So it is my pleasure tonight to introduce Brian Frye, who is the Spears Gilbert Professor of Law at the University of Kentucky J. David Rosenberg College of Law. He received a JD from New York University School of Law in 2005 and an MFA from the San Francisco Art Institute in 1997, and finally a BA from this august institution, the University of California at Berkeley, in 1995. His research focuses on intellectual property and charity law, especially in relation to artists and arts organizers and arts organizations. Brian is also a filmmaker. Among other things, he produced a documentary, Our Nixon, in 2013, which was broadcast by CNN and opened theatrically nationwide. He also produces Ipse Dixit, a podcast on legal scholarship, which can be found at play.acast.com. Moving on to our next panelist, I am very, very pleased to introduce Mary Kathryn Nagle. Mary Kathryn Nagle is a partner at Pipestem Law. She's a frequent speaker at law schools and symposia on issues related to restoration of tribal sovereignty, tribal self-determination, Indian civil and constitutional rights, and the safety of Native American women. She's also an accomplished playwright who has written and produced several plays relating to Indians in the law, including Wahe's Law, Mannahatta, My Father's Bone, co-authored with Susan Schoen Harjo, Mislead, that's spelled L-E-A-D, Fairly Traceable, Sliver of a Full Moon, Sovereignty, Crossing Minnesota, and finally, Return to Niobrara. Mary Kathryn Nagle is also an enrolled citizen of Cherokee Nation. Our next panelist, whom I am very pleased to introduce, is Phillip Gotanda, who is the professor and vice chair of the Department of Theater, Dance, and Performance Studies here at UC Berkeley. Over the last 3 decades, playwright Phillip Gotanda has been a major influence in the broadening of our definition of theater in America. Quite an accomplishment, in my opinion. Through his plays and advocacy, he has been instrumental in bringing together stories of Asians in the United States to mainstream American theater, as well as to Europe and Asia. He also holds a law degree from Hastings College of Law and studied pottery in Japan with the late Hiroshi Sito. He is also a respected independent filmmaker. His film, Life Tastes Good, was presented at the Sundance Film Festival. He, alongside Michael Sasaki, did a Chinglish version of My Boyfriend's Back, with Joan Chen singing lead on Hong Kong pop charts before it was banned, which is so cool. Phillip is a recipient of a Guggenheim as well as other honors and awards. Finally, and last but not least, and I'm very pleased to introduce our final panelist, Elizabeth Kovats, who's a lecturer on innovation and design at Berkeley Haas School of Business. Elizabeth has created new courses at Berkeley Haas and Berkeley Law in the area of design thinking, often teaching law students on how to apply design thinking to their own work. She also served as director of the Berkeley Roundtable on Applied Innovation and Design, BRAID, or BRAID. Through BRAID, she regularly collaborated with innovation executives based in Silicon Valley. Her area of interest is in design and ethics and how we can design products and/or processes to advance the common good. So those are our 4 panelists tonight. With that, I want to stop talking. I've already talked too much, and offer our panelists an opportunity to just offer some brief remarks on the theme of empathy, law, creativity, and the arts. And let's go ahead, Elizabeth, if it's all right with you, in reverse order, and have you start first.
Thanks, Sarang. Thanks so much for those introductions. You have a great intonation as you read. In terms of opening remarks, I will keep it brief because I think our discussion will probably bring a lot of ideas to light. But a couple of things that initially jumped out at me were the relationship that art can give to law, and then of course what law can give to the polis or society. And so one thing that art does very well, I think, is perspective. And the ability to adopt different perspectives can be very important for all facets of life, and of course law and how we relate to one another. And then in terms of the law giving, I think the law emphasizes diction and language, and understanding that how we name things and how we understand concepts really can go a long way in helping us to be more equitable with those around us, and with respect to ideas of justice and so forth.
Thanks, Elizabeth. Phillip, would you like to jump in with a couple of brief remarks?
Yes. Thank you for having me, and I feel honored to be on this panel. I'm going to talk about the issues from my point of view. Let me kind of change this gallery view to, let me see. Okay. I'm going to talk from the point of view of being an artist. I'm a practicing artist. I'm not a practicing lawyer. And I thought it best that I talk from that point of view. And so one of the things I'll talk about is that I'm going to talk about creativity, the act of making art, and how I am wondering if in fact they come from different streams of thinking as opposed to the law. And this isn't so much after they've kind of been allowed, creativity has been allowed to create a piece, but in the origins of the process of inspiration, of creativity. Just to give a really quick kind of anecdote, I spent my entire life as an artist. I went to law school, and I had a very difficult time in my first part of my law school career. I realized that I had spent my life prior to that, as well as my life subsequent to that for the next 35 years, working as an artist. And what I came to realize is that I had trained myself also to think as an artist. And it does ask of you to approach and negotiate issues and arguments differently. What I found is I had a difficult time reading textbooks, cases. It wasn't that I didn't understand them, it's that as I read them, I continually bounced out to entertain other ideas, which is part of how I had trained myself in my creative life. So I found that it required me to rethink and kind of rediscipline myself so that I could, in fact, read a case, follow it in a linear fashion, and stay with it till its final outcome, which is true in creating theater, but at the same time, the journey there is much different. You drop in the middle. You start at the beginning, jump to the end, then finish the middle. You think like this. You take wide looping circles out of the argument and then return to it again, only to find that, in fact, you can't use it anyway. But that is part of the thinking process to, as far as I see it, as art making. And so I'm going to talk somewhat about that. And just the idea that, for me, they do come from, in their origins, different streams of thinking.
Wonderful. If my first year law grades were any indication, I too had a very similar difficulty, Phillip, with adapting to law school. So I'm really glad to hear it wasn't just me. So with that, I would love to just turn over to Mary Kathryn Nagle for a couple of brief remarks and thoughts on tonight's theme.
Thank you so much, and I hope you all can hear me. I apologize, I've been having some Wi-Fi difficulties, which is very challenging for both the lawyer part of me and the artist part of me. But, you know, I just really appreciate being invited to this discussion. And, you know, I have always felt like so many people in the world, if you're a lawyer and an artist, always want to say to you, well, when are you going to give up one for the other? Or when are you going to realize that you're really an artist and not a lawyer, or really a lawyer and not an artist? And I do not find the two mutually exclusive. And I think any lawyer who does not know how to tell a good story, whether it's through a painting or a song or a play or a movie, is not going to be a good lawyer. And not that you have to be a visual artist or a performance artist to be a lawyer, but being a lawyer is performing, right? And it's performing whether you're in the courtroom, whether you're arguing before the Supreme Court, whether you're writing a brief in a county court there in California, you know, whatever it is, you're telling a story, and that's what you're doing as a playwright. And so for me, being a playwright has always felt very symbiotic to being a lawyer. They feel like they're one and the same to me. And although I have met resistance from folks who see them as sort of two polar opposite careers that individuals would decide to take instead of something that someone, I mean, the only conflict, let me tell you, is time management, but that's a whole other topic for a different seminar that maybe all of us could benefit from. But, you know, I think that one thing I will say is that when I was in law school, I went to law school, and you know, so most of, I think probably the students that are here tonight have either decided to get their MFA or some other degree at Berkeley or go to law school. And those choices aren't mutually exclusive either, right? I certainly had a lot of people tell me, you better go to law school because you want healthcare. And, you know, that's a whole, again, the healthcare system in the United States, that's a whole other conversation for another seminar. But the reality is that I remember choosing to go to law school, and I always wanted to be a lawyer, but feeling heartbroken at first that I was giving up my dream of being a playwright by going to law school, and really felt convinced of that for many reasons. But I can say this, that when I got to law school, my first year, Hurricane Katrina, I went to Tulane, Hurricane Katrina hit, and we were ravaged, the whole city was. And for me, art and theater and storytelling is a form of healing. It's a form of coming together as in community. And so what I quickly did was worked with other law students, professors, staff, alumni of Tulane Law School to interview them and write a documentary play about the hurricane that when we all came back in January of 2006, we all performed together, including professors. And folks who told me, well, I have no acting bone in my body, were amazing performers. They were wonderful. And it was such a success that I was asked to write a play for my fellow students and faculty to perform the next 2 years I was in law school. So I just appreciate this chance to sort of unpack some of those myths around things that we have to put people into buckets or things have to be separate, and to really dive deep into what those connections are. Because I think no matter what quote unquote careers everyone chooses, we carry both of those, all of those with us at all times.
Thank you so much, Mary Kathryn. I completely agree with the notion of refusing to choose. I think that a lot of our sort of human spirit often covers these wide territories that can't fit into one bucket or another. I'm also really appreciating this theme that seems to be emerging already about placing oneself in another person's perspective, as Elizabeth mentioned, as a way of relating to things that are happening in the society around us. So I think that's really interesting and something I think has a very deep connection with law. So with that, I'd like to come back to a last panelist to give a brief remark. So Brian, whenever you're ready, feel free to take it away.
Thanks, Sarang. I really appreciate you inviting me to participate in this panel. It's a great honor to return, if only virtually, to my alma mater. And as it happens, I felt it was important to recognize that I first realized I needed to make art as a 17-year-old Berkeley undergrad sitting in the BAM PFA theater watching Jonas Mekas' film Walden. And it's for those who, maybe some of you haven't seen it, it's a 3-hour film exploring his own experiences as an emigre and an artist. And there were about 5 people when the movie started, and when it ended, I was the last person there, the only person there, and it changed my life, right? So that was sort of the story that led me to go later to art school, and then eventually to go to law school, where I gradually, I guess, found a path to what I do now. So my friend Emily Bremer a few years ago observed that that I was an artist who worked in the medium of legal scholarship. And I never thought about it that way before, but she was right? I mean, I actually found my artistic medium, and it was the law. And so I try to spend my time making legal scholarship that satisfies what I see as the criteria of art. And I guess maybe I have a somewhat idiosyncratic definition of art, which I thought I'd just throw out there for the benefit of discussion, which is I like to think of art as a consumption good that consumers don't understand.
Wonderful. I was really hoping that someone would try to contest the categories that of art and law that we've set out for ourselves. So I really appreciate this definition of art. And so what I want to note here is first that first on a sort of practical manner, I invite the panelists to from at this point basically just unmute themselves and feel free to pipe in or jump in with their thoughts on the questions that may come about and what their fellow panelists will say. There's a lot of questions that I and I think a lot of other folks came into this panel with about this particular intersection. But one thing that I noticed, and I feel like at least I relate to, is this question of like doing both. And so I just want to note that, like, well, when it comes to the way that Brian looks at it law as an artistic medium. Both Phillip and Mary Kathryn, and correct me if I'm wrong, look at art as something that is an essential, necessary, integral supplement to their understanding of law and of society. And the way that I think Elizabeth is describing the necessity of perspective is that art is actually this first stage from art to law to living in a polis and living in a political society. And so I guess like what I want to hear from all the panelists is like, how did you arrive at the specific personal understandings of art and law and how they relate to each other, because I think that would be really interesting. And I really want to hear, you know, as Phillip mentioned earlier, I really want to hear some of these like personal stories and anecdotes of like how exactly you got to this view and this vision yourself. And so to avoid the Zoom awkwardness, I'm going to go ahead and toss it to Phillip first. But then after that, you know, panelists, feel free to just pipe right in.
For me, the kind of, the entry point was politics. You know, I'm a child of sort of the late 60s into the 70s as the Asian American movement emerged. And prior to that, I was doing art, writing stories, making songs. But, you know, oddly enough, at that time, if it's hard to believe, this face, this body story was not in the center of any story or play that was being done at the time. And so the emergence of the Asian American movement allowed me finally to sort of find a kind of a way to apply my sense of social justice, systemic racism. All of that kind of became clear to me in terms of why I acted the way I acted, who my community was. And so that afforded me kind of an entree into having a vehicle to write about stories dealing with Asian Americans, while allowing, again, getting back to this impulse, this creative urge or impulse, which it gave it a way to have a certain kind of clothing, a certain kind of face. And so that was my entry into kind of writing about, or writing stories about being Asian American, writing art. And it was through that political kind of movement that afforded me kind of a way, an intellectual kind of room to understand and negotiate the world.
Hey, Mary Kathryn, maybe you could jump in with some of your own story on how you connected sort of politics with art.
Yeah, absolutely. So, you know, I grew up, you know, with my grandmother telling me the story of how when in the early 1830s, when the legislative branch of the government and the executive branch of the government were seeking to exterminate us. I mean, Andrew Jackson ran, his presidential campaign platform was eradicating tribal nations in the Southeast, including my nation, Cherokee Nation. And the Congress at that time passed the Indian Removal Act, which we can debate the constitutionality of that act, but it did pass. And Jackson signed it into law. And so we had this moment with the Supreme Court's decision in Worcester v. Georgia in 1832, where the Supreme Court was the only branch of the federal government that recognized our inherent right to exist. And so as a young child, I sort of felt like, wow, like the courts, you know, and my great-great-great-grandfather, John Ridge, was one of the very first Native attorneys in the history of the United States. Of course, he couldn't argue in the Supreme Court because if you were Native, you couldn't argue in a federal or state court in the 1830s. But in any event, he was a lawyer and one of the first. And so I grew up with a deep respect for the law and the courts vis-a-vis other branches of our governmental system. And fast forward to sitting in law school, and I start reading some of these decisions like Johnson v. McIntosh from 1823 that says, you know, tribal nations. So there are other really problematic decisions out there, I guess, is what I have to say. And for instance, Johnson v. McIntosh, where the court held that, you know, tribal nations cannot claim legal title to their land because they're quote unquote racially inferior savages and heathens who don't worship Christ. And, you know, these, I mean, that's in this 1823 decision that's never been overturned. It's still good law today. And you can draw a through line to the court's 1978 decision, where in Oliphant, the Supreme Court eliminated the inherent criminal jurisdiction of tribal nations to arrest and prosecute non-Indians who come onto tribal lands and commit crimes. Now, what does that have to do with art? Well, I can tell you that after I graduated from law school and moved to New York, I was blessed to be invited to be a part of the Public Theater's Emerging Writers Group and became one of the playwrights housed there in that fellowship. At that time, I lived in Manhattan for 5 years. I didn't see a single professional off-Broadway, I mean, forget Broadway, but off-Broadway or any kind of other professional theater in New York produce a single play by a native playwright. I did, however, see about 10 productions that used red face. And that varies from Bloody Bloody Andrew Jackson that went to Broadway, where they actually celebrated Andrew Jackson as a sexy rock star. I mean, imagine celebrating Hitler as a sexy rock star. I think that would be problematic. But this was, you know, a widely accepted musical that was taken to Broadway. And so I think I very quickly realized that the problematic laws from the Supreme Court on the books are not created in isolation. You don't get laws that say Indians are savages and therefore their governments can't prosecute a non-Indian who comes onto tribal lands and rapes Native women without a culture that dehumanizes us. And that culture is on our stages. It's in Disney's, you know, Pocahontas movie. I mean, you can look at all these examples in the movies, but I work in the theater. I'm a playwright and my medium is the theater. And so I was living in New York and going to theaters and not seeing anything by a fellow Native playwright and only seeing a Native person depicted on stage if they were in a dehumanized, fake, you know, misrepresentation form. And so what that meant for me personally was that I needed to do both, right? I couldn't just write briefs and file them in the Supreme Court and expect everything to be fixed, right? You've got to move the art and the culture to change the false, I think, prejudicial belief systems that give rise and perpetuate these harmful laws, right? Because harmful laws, racist laws, prejudicial laws are just based off of ignorance and mischaracterizations of people that were created purposely. Blackface created purposely, red face created purposely. There's no accident that the most famous red face performance that popularized it in the United States was created in the late 1820s at the same time that Andrew Jackson was running for president of the United States on a campaign platform of eliminating savage American Indians. So I very much see the connection and the need to do both to achieve legal change in the United States.
Yeah, I think this is actually something that's super interesting that seems to be emerging from what you all have said so far. One is the idea that like art and culture create law. And the other is that law also, in a sense, comes back and creates art and culture. That there's a reflexive relationship between art, culture, and society, and law, and then law and art, culture, and society, where they both mutually influence each other in a cycle. The other interesting thing that seems to be emerging is this idea of marginalization and breaking the cycle of marginalization and of, you know, a country, I think especially relevant in the time we live in now, like, and I think over the last 200 years, a country in which that marginalization is a very explicit part of like how this country is structured, run, and constitutionalized. So I just wanted to put that on the table because I think it's really interesting. And with that, I actually want to turn to Elizabeth now because I think that this might relate to some of what you were saying earlier, Elizabeth, about the relationship between art, law, and the polis.
Sure. I guess I would say, so personally, just to answer the personal question, I studied creative writing as an undergraduate, poetry. And so academically anyway, I locate myself very much in the humanities and think of myself as a humanities baby. And then professionally, when I was an undergraduate, I swore my whole life I would never go work in an office and have a 9-to-5 job. And of course, that's precisely what I did when I graduated. And so I would always have these, you know, moments of crises, like what am I doing? Why am I here? You know, et cetera, et cetera. And so then when I came to Berkeley and transitioned to teaching, I found it was around the advent of what we call design thinking or human-centered design, which is this framework that emphasizes empathy, creativity, and multidisciplinary collaboration. And so you can use this framework if you are, you know, going to design a new voting process, or you can use it if you are going to design a new phone, etc. So it can be used for a whole different, you know, you can redesign an educational system, which has been done in Peru. And so this framework for me, I finally kind of felt at home, if you will, because you could start to bring in both critical thinking, systems thinking, etc. And as you're kind of weaving in these different approaches, as Phillip was mentioning, like these different types of thought processes. And so in terms of going back to this idea of perspective and law and the polis, I'll just quickly share my screen. Let's see, hopefully. This is probably something that many of you guys have seen. And it is the duck rabbit drawing. So are you guys good on seeing it? Yeah. So the guy that invented, so some of you, if you haven't seen this, you might see a duck right away. And then you also might be able to see a rabbit. So the duck is looking in one direction and the rabbit's looking the other direction. And what is significant, according to the person that invented this, is not whether or not you see the duck or the rabbit, but it's that perspective is a mental activity. You can, you have agency over what you see. And so you have the ability to adopt a different perspective. And we often understand that ability to adopt a different perspective as a driving force of empathizing with another human being. Let me see something from your shoes, let me see something. And so this idea that each person's window into this big thing that we call truth is just that, it's a small window into the truth. And so if you want to think about the truth of something, generally the more perspectives you get into that topic, the more sense of the truth of it you might be able to ascertain. And so, as I mentioned, I think art is a really great way. So I'm just, here are some photographs. This is Sebastião Salgado, who's a great photojournalist. And so here you have this photograph of these penguins in Antarctica. And then another photographer, James Drury, of the feather, very close up with some raindrops on it. And in literature, we of course have first person, second person, third person limited, third person omniscient. All of the playwrights, fantastic playwrights on this panel. Art is a fantastic, different art forms really give a sense and importance of perspective. Like, oh, I can look at something in a different way. And so in terms of, what that means for our, I would say, responsibility as human beings, perhaps as legal scholars and so forth, as those whose very work impacts so many people. What is your, actually, Mary Kathryn, I saw a great quote recently that said, Americans think of themselves as having rights, and Native Americans think of themselves as having obligations. I have to care for the past, to care for the present, to care for the future, my fellow humans, my environment, etc. And so those ideas about how we live and how we treat our fellow human beings, and ideas of justice and forgiveness and healing, empathy and perspective, I think just go hand in hand and are so instrumental in doing that. So I don't think that, I certainly would not divorce art at all from any discipline, or to say like it's irrelevant or something like this. I mean, I heard all those same, silly questions that people, oh, how are you going to make a living if you study film, or if you study this, or if you study dance? And I think we do a disservice to our students with that. So you have, when students are majoring in computer science and they're majoring in data analytics and they're majoring in business, we think they're going to get a good job. And if they major in something in the humanities, well, they're going to be starving for the rest of their lives, and so on and so forth. But I think creativity has to be democratized. You can be a creative computer scientist, you can be a creative business person. It's just that the arts, I think, concern themselves with humans, with actual humans, and understanding the human condition as a course of, as the primary purpose of art. And so that human element is distinctive and quite additive, I think, to the field of law and as I mentioned, other fields. So with that, I'm done. Thanks.
Elizabeth, I really appreciated an opportunity to exercise some visual thinking, speaking of different ways of thinking. And I love this Aristotelian idea that art helps us cultivate a sense of moral justice. And how can you have law without moral justice, which itself requires perspective? So I absolutely love that idea and the demonstration of duck and rabbit. Yeah, I'll offer it to Brian if he had any thoughts now.
Sure. So I guess I think art has a lot to offer law, because art makes the world weird and hard to understand. And law is about making things normal and justifying or reifying them. And so I think it's good to do art in law because it helps us break the spell that law puts over the way we think about the world. I will say that I'm skeptical of the idea that art is about, well, I'm skeptical of the idea that art is about creativity, or that we really care about creativity, right? Or at least in the context of what we do when we do law around cultural production, what we care about is consumption, right? I mean, when we do law, what we care about is producing things that people like and understand and can make sense of. That's not creativity, at least as I understand it, right? I mean, as I understand it, creativity is something, or art is something more and different and weirder than that. And there's nothing wrong with enjoying things. You know, I think that's really good, and we should encourage that. But I think that art offers us the promise of something more and deeper and richer and weirder than what we want. It offers us the promise of something we don't know we want, or something we don't understand, or something we don't know what to do with yet. And I think that bringing that to law could potentially be productive and helpful, right? I mean, the law is so set in its ways. You know, I mean, the law is all about conformism and about doing things the way they've always been done, and not questioning how we think about the world, and not, you know, I mean, you just look at legal scholarship, right? I mean, it's literally the most boring form of literature on the planet, right? And we seem to love it. And I don't understand why. I think we can do better. And I think art offers us a tool for thinking about how we can do better.
Yeah, I think that's a really interesting idea, that art is, I mean, in a sense, it sounds a little bit like you're saying that art can actually, there's a sort of transcendent quality, and not literally something that exists outside the bounds of like a capitalist consumption paradigm that art brings to the table. And so like art's integration into law and other things, I mean, it's still part of this society in which everything is oriented around like profit and consumption. And so that's an interesting idea, because I think, if anything, the concepts of law and transcendence are fundamentally divorced in most people's minds. Okay, so, you know, we don't have a lot more time before we jump over to questions from the audience, and I want to make sure we leave enough time for that. So I'm going to mention two things. First off, for all of you out in audience land here, just want to remind you, feel free to drop in questions into the Q&A function in the Zoom webinar. And for those of you who, for whatever reason, can't do that, you feel free to drop in a question into the chat, and we'll try to make sure it gets into the fray somehow. And so I just want to bring up one idea, and then I just want to leave it to the rest of you for the next 10 minutes or so. I've been fascinated by this idea that Jean-Paul Gressier told me about. He's one of the organizers of this panel, of what John Keats calls negative capability. Negative capability is a capacity to pursue a vision of artistic beauty, even when it leads the artist or whomever into intellectual confusion and uncertainty. So I wanted to bring that up because I think Brian was already heading in that direction, and I wanted to just throw this and all the other interesting things you guys have talked about out there in the open for the panel. But I guess I wonder, like, what are ways that law can embrace that negative capability, that ability to head into uncertainty and confusion, and how could that be important in this time of chaos and this time in which we're reevaluating everything, even down to the constitutional and individual level? And so with that, I'm going to just experiment with letting the panelists take it away.
You know, when I first saw that, I kind of wish I could see that again. Something struck me as kind of odd about that statement, and that it was kind of saying as if art in some way was equitable to this kind of whatever rational thought. And so I guess to me, it didn't quite make sense that confusion and that kind of dissonance and equating in some way to what art is, I found it didn't work for me, because it seems to me that art has its own way of being not confusing, and has a way of getting rid of dissonance by, in its own way, kind of expanding sort of rational thought, kind of expanding sort of the connections between word, between associations, so that we're able to see kind of dimensionalized ways of looking at things. And so to me, that particular phrase doesn't quite work for me. They don't quite add up in quite the same things.
Maybe I'll take a stab. I really appreciate Sarang and Jean-Paul, you guys bringing this to our conversation. Keats wrote about this, I think, in 1817, 1818, or thereabouts, and scholars kind of try to piece together what he means by it, because he only mentions it in one letter, but then in other letters before and after, he kind of alludes to it. And Keats loved Shakespeare. He thought Shakespeare was a master of negative capability. And it's this idea, I don't think empathy was maybe common parlance for them, but it sounds very much like empathy. Keats thought that a person should be a person of sensations rather than a person of thoughts, and that they should try to empty themselves of their thoughts and their opinions so that they can really understand their subject and write about their subject. And so in many ways it is very similar to empathy, I think. And in terms of how it could relate to law, one thing about language that I will bring up, I said in the opening remarks, the importance and emphasis of that law has with respect to language. If I say the following words, visitor, immigrant, emigrant, migrant, emigre, refugee, illegal alien, these have different connotation, like they connote different things for us. And fundamentally what it is a person who is living outside of the land into which they were born. And how we treat those people that are trying, it says so much about who we are as a society. And I think Keats said that a person's potential can be defined by what he or she does not possess. And if we think about just the very topic of immigration and the language that we use and how the law approaches this field, and does it create language that distances us from the other, or language that unites us with the other? And again, that a person's potential is defined by what he or she does not possess, right? So that's all I'll say on that. So thanks.
If I could jump in on that briefly, I primarily write in the area of intellectual property and specifically copyright law. And the law tends to think about expression in terms of ownership and property. And I think one of the nice things about art is that it at least offers the potential for questioning the legitimacy of those ideas of ownership and property and control. And that's one of the reasons that a lot of my scholarship is focused on questioning the legitimacy of plagiarism norms, which I think get to the hypocrisy of artists who themselves cling to ownership as well in ways that I find, questionable and illegitimate.
Mary Kathryn, you want to jump in before we head into audience questions?
Sure, I can. I'm not sure that I have a whole lot else to contribute to what I think were some very amazing answers to those questions. But one thing that jumps to mind is and I'm not going to profess to fully understand this term, negative capability, but in terms of the ability of art to take a construct that is already just accepted as fact, even when it's not. For instance, like you can look at what Justice Powell did during his time, which was really completed by Justice Scalia and Lujan in 1992, the creation of this fairly traceable doctrine, which that language isn't anywhere in Article 3 of the Constitution, but it's considered an Article 3 jurisdictional doctrine that as a plaintiff, the federal court has no jurisdiction to hear your claim unless you can show that your claims are fairly traceable to the conduct of some defendants and not some other third party. To me, that is art. That is creating that is creative work at its core, because it is not there in the Constitution, right? And so just comparing that to the work that we do as playwrights, and I can tell you that I actually wrote one, as you mentioned, one of my plays is called Fairly Traceable, and it actually explores the creation of this judicial doctrine through a critical lens, and showing how it's very easy, as Elizabeth was talking about these different perspectives. I think sometimes when we go to law school and we're just told we have to memorize this law for the exam because this is what the law is, and then if we just step back and look in the other direction, it's like, but those words aren't in the Constitution. Who decided this? Okay, it was Justice Powell. You got a few other justices to sign on. Scalia followed up. I mean, it's a handful of people here. And so no disrespect to the Supreme Court, but we have got to be, I think art can become that tool that can help us kind of step back and shift our perspective.
That's a really great point. And if we had a little bit more time, I would, and I always relentlessly plug this to everyone I meet, but there's a classic essay by Elaine Scarry called The Made Up and the Made Real, which tries to, I think, explore exactly that vision of law and interpretation that you're talking about, Mary Kathryn, how law is itself a social construction. It's a creation of people. And that for whatever reason, we see art as a social construction on its face, but we don't see law the same way. We see law as being imbued with authority and having like the weight of history in the Constitution. But I could go on. I'm going to actually jump right into questions here, because I see actually a great question for you, Mary Kathryn, from, let me just make sure I got this right, from Justin Gonzalez. Justin asks, how can emerging artists today help to elevate and defend underrepresented and marginalized voices and perspectives? So that's for you, Mary Kathryn. So feel free to answer it. Also curious to hear what the other panelists have to say.
That is a great question, and I really thank you, Justin, for asking that. And I think that that work has to be done intentionally. And there's a lot of there was a huge social movement that happened in our country this summer after the very tragic and unfortunate murder of George Floyd. And I think that what happened is a lot of people were awakened in this country to, trauma can sort of have the same effect of art, right? Because art opens our hearts and our minds, and trauma can sometimes, even though we wish it never happened, I think bring people to a place where, because the trauma inserts itself and sort of breaks up the ordinary, normal routine and acceptance of the outside world, makes us start to question the constructs around us. And I think that's what happened this summer. And so my point is just that a group of diverse theater artists, I was honored to sign my name to the letter, but I can't claim credit for it, called We See You, and you can Google them and hashtag them, but it's just a group of artists of color in the American theater writing letters to those theaters who don't have a single non-white male leader at the head of their, artistic team running the show and deciding whose plays get produced and whose don't. And the fact of the matter is that the majority of the plays produced in this country are still, plays written by Shakespeare or other white, seemingly straight men, and we love those guys, they're great, but there's a lot of other folks too, right, whose voices should be heard. And I think that it's not about not producing plays by white men, those plays should still get produced, but it's about including other people and making sure their voices just aren't silenced. And I think it's just interesting to be having that conversation about, and to be very practical, what can you do? I think I recently had a play produced by Marin Theater Company there, not too far from Berkeley. And I know that the artistic leadership there has worked very hard to be inclusive and to include artists of color and artists of different backgrounds and identities, whether it's, sexual orientation or socioeconomic class or different abilities, things like that. And I think that's really important, but you can always engage with your local theater in your community and say, have you ever produced a play by a Native playwright? Have you ever produced a play by a visually impaired playwright? Have you ever produced a play by an immigrant playwright? I mean, you can just ask them these questions. And I think when their community and their constituency demands diversity, then it becomes a lot harder for them to deny it. And I just also, the little, part of me just is always so curious and interested to see that these conversations are happening about our American theater at the same time they're happening about the composition of our Supreme Court. It's just a very, very interesting time right now in the United States.
If I can briefly add to what Mary Kathryn just said, it's never been easier to produce content and make it available to people. And when you do that, you can think about who you talk to, who you listen to, and who you promote. And I think doing that is a very easy way to recognize and elevate people from communities who aren't otherwise getting the attention that they deserve. And why not do that? I know that when I think about who I want to talk to for my legal scholarship podcast, I do my best to speak to women and minorities and students and untenured people and so on. I think just being intentional about that goes a long way.
So I actually wanted to jump into another great question that Justin asked in the chat. Give me a moment, I'm looking for it right now. And I think this relates to some of the themes that came up during the earlier part of today's panel. Justin asks, or says, prior to this lecture, I saw law as a rigid and unbending system, whereas art can be dynamic and subversive. So Justin has two questions. How does law influence the format and relevance of your artistic works? And also, in what ways does art inform your changing ideas about law in our society? I also want to just add to the panelists that it looks like we've had some positive responses from our audience about like your big aha moments. So, feel free to continue sharing those, because I think I know personally it really helps to like kind of love to hear how people kind of arrive at where they are. So again, the questions are, how does law influence the format and relevance of your artistic works? And also, in what ways does art inform your changing ideas about law in our society?
Well, not to monopolize the conversation, but I would push back against the premise. I think in a lot of ways, the art world is very formalistic. And as an artist, you can make anything you want to, but that doesn't mean anyone cares, right? And to the extent we talk about art, we have expectations about the context in which it'll be produced. And there's a very limited subset of things that anyone notices or talks about or pays attention to. Interestingly, by contrast, I actually have found that legal scholarship, for example, is quite accepting. You can publish almost anything, and God knows what people might notice or pay attention to. or talk about. So I'm not entirely sure that, you know, that kind of distinction makes sense to me. I think that people have very rigid ideas about what they're willing to accept as art in the moment, and maybe they don't see something as art until many years later, but maybe that's what makes it art in the first place.
You know, if I can add a little bit to that, I think there are moments of art that actually, for me, have broken open sort of the sphere of my aesthetic argument. And that, you know, for example, there are two cases. One is the first time I saw Sankaijuku, when they first arrived in the country. And they're the ones that do the buto, that now has become to some degree a parody of itself. But Sankaijuku, when I saw them, they literally shifted my head. And I can't even explain, my aesthetic shifted. And that was one of those moments where, for me, when you see something that just, it's so pure and truthful, and it just shifts how you kind of view the world. I think art can do that on occasion.
Yeah,
If any of the other panelists have thoughts, oh, go ahead, Elizabeth.
well, I was actually going to talk about the question of the limitations of this approach. So if people wanted to continue this, then jump in.
Yeah, so that is one of our top questions in the Q&A, and I actually really like it. So I'm gonna repeat it here. At what point would you say art and law cannot relate to one another? And I would actually really love to hear all the panelists talk about sort of the flip side of, you know, what we've been talking about all night, which is the intersection. So Elizabeth, if you want to take it away, I'd love to hear your thoughts.
Thanks, Sarang. I'm going to be a little bit circuitous here, so apologies for that. But just as a sense of, so if you were to take a human-centered approach and apply it to how the law is operating, you know, we often talk about things as being prototypes, or in the art world, it would be a rough draft. It's something that is unfinished. But if it's a prototype, you can put it out into the marketplace or into the Polis and collect information. And so we spend about 6 months drafting legislation, and then once it's passed, we don't bring it back in for revision. It's out there. And so if you were to take a human-centered approach, you would say, well, nothing we do is ever perfect. So let's spend 6 months or even shorter drafting a bill. Let's put it out into the world. And let's have a process whereby every 18 months or 2 years, we bring it back in, we see the places where it's working, where it's not working, and we revise it. And it was interesting because with Obamacare, the Trump administration actually wanted to bring it back in and make revisions, and everybody was up in arms. And there was a part of me, the process part of me was like, no, this is a good thing, we want this. But then that's where you get into the idea of the spirit of the law, and the worry is that the spirit of the law would not be upheld, you know, under this new administration. But this idea of sort of prototyping your way forward, understanding that we never get everything right. There's probably never going to be the perfect people in the room at any given time, and so forth. And so just trying to collaboratively and work together and understand that we're always limited. And so let's, you know, not leave things written in stone. Let's make them written in sand, so to speak, and we'll keep revising them. So anyway.
Again, for the panelists, the question is, at what point would you say art and law cannot relate to one another?
Well, I mean, I would say that in the area that I work in, art and law are having a lot of problems right now, right? So, I mean, in the area of copyright law, I think lawyers and judges have a very hard time wrapping their heads around what artists do, why they do it, what it means, and why it matters. And I think it's hard for the law to internalize, understand, and incorporate the kinds of sociocultural expressions that artists engage in. At the same time, I think artists engage in their own version of quasi-ownership that sort of operates in parallel to but distinct from copyright law, where they create their own rules and they create their own law, and it's oppressive in its own way. And I think the two systems might be able to inform each other and help us think about what we collectively want to accomplish, what we're trying to do, and what values are at stake in the kinds of rules and expectations that we're adopting, and I guess one thing I would throw out there that I always think is important, as a copyright scholar and as a copyright skeptic in a lot of ways, that I think is important to think about is, to what extent do artists want to be landlords, right? To what extent do artists want to be owners? To what extent do artists want to be charging rent? To what extent do artists want to be controlling other people's speech? And how should we think about that?
I have one thought. What you say makes a great deal of sense. Certainly with a capitalist kind of model in looking at art. But I'm simply say, as an artist who, when I'm creating something, I am not thinking in terms of ownership. I am not thinking, again, this could be an interpretation each of us has as to what that word means. What I am looking for is trying to put together a story. That is to say, the satisfaction is allowing sort of the pieces to come together so that it tells a story that is a consistent world. In that sense, it's selfish. But it isn't, certainly at that juncture, about, for me, ownership. That happens after after the thing is created. I call it a product. After it's created, then it gets involved in those aspects. But I know for me, the process of when I make something sometimes is, I don't know why. There's so much stuff floating around. I know this doesn't fit well in an argument talking about the law, but I just must say that stuff floats in, floats out, and that I'm just struggling with that world to put together something that expresses whatever it is that's coming out of me. And but anyway, that's my thought, Brian.
Yeah. No, I like it. I mean, one of the interventions I've been engaging in lately is trying to question ideas around artistic ownership. So among other things, I've written papers in which I encourage people to plagiarize me. I also wrote a recent paper in which I offered to give people authorship of all of my recent, of all of my scholarship. So I'm transferring the attribution right to people. The point of which is just to ask why I can't do that.
Yeah, no, that makes sense. I understand that.
Yeah, I wanted to offer Mary Kathryn an opportunity to jump in if she had any thoughts.
Yes, and actually, I think I may have. Let's see if this is working now. I may be able to be here in video
Hooray.
too. I think the Wi-Fi issues may have resolved, but if I drop off, I'll sign back on. But yeah, as most of these conversations go, I hear the question and then I hear what everyone else has to say, and I get excited and want to respond to what my fellow panelists have said. So I'm going to sort of cheat and not directly answer the question, but respond to interesting things other folks have said. And one thing that Elizabeth said really caught my ear, and she was talking about sort of the way in which the sausage is made in DC and legislation on the Hill. And it is really counterintuitive to think of, okay, we're just going to draft something and then there it is. Of course, there's, an opportunity for Congress to always amend laws, but we know how well that works. And it's just, and I do have to say one just interesting observation, and maybe other folks have had this observation too, is that, you know, every day of my life, I'm either writing a play or a brief. And it is so funny. You know, my play Sovereignty, for instance, I started writing it in 2015, and actually there's a theater in New York that's going to be doing, we just did it at MTC out there in the Bay Area last year, and there's a theater in New York that's about to workshop it, and I'm going to do more revisions to it in a few weeks. So I've been writing this play and constantly rewriting it, and significant revisions, like 20% of the script or 40%, since 2015. I've also submitted in the Supreme Court probably 8 different briefs in that time, that, you know, you submit it, it's done. There's no going back and, oh, you know, on further reflection, the way I frame this legal issue isn't actually the best way to approach it. You don't get to do that. And same thing with judicial opinions. And of course, we all need finality, and the law, you know, there is, you know, certainty in the law, and there wouldn't be if, you know, let's say the Supreme Court issued a decision and any of the justices could change their minds at any point in time and rewrite their dissent or join the dissent from the majority, or that would be chaotic and problematic. But it's just interesting to think about these 2 different ways of what I see as both storytelling. As an artist, I'm always, you know, I may not say it, but let's be honest, I'm trying to persuade the audience to believe something. Maybe it's just believe that Native people are humans too, and we're not just mascots, right? We, and our governments are legitimate sovereign governments, and just believe in our legitimacy. But that's a message, that's a purpose, right? Same thing when I write a brief. I may be advocating for the Supreme Court to decline Oklahoma's invitation to judicially disestablish Creek Nation's reservation. But, you know, when I write a play, my purposes aren't that different, right? It is persuasion. Now, I'm sure there are some artists who would say, I'm not trying to persuade anyone, I'm just expressing myself. But I also think that that's a form of persuasion in and of itself, like that you have a place in society where you get to do that, right? And so there's a story you're telling, and I think probably most artists believe that they should be heard or listened to, or observed in terms of the art that they're making. And so just the different processes and approaches in creating them is really interesting.
So I think the story, like, idea of storytelling, persuasion, and as Phillip was saying, the kind of, you know, shifting of perspective and aesthetic view, I think is a really interesting question, which is why I want to bring up a question that popped up in the chat or the Q&A that caught my attention by Katherine Missouri. Katherine asks, if there's time, you may all be aware of the arts in Afrofuturism and Asian futurism. So is there a law futurism, in a way that the arts can pressurize law into more radical premises, interpretations, or ways of performing now? I thought that was interesting, so I'd love to hear if any of you have thoughts, or again, feel free to respond to each other as well. This has been very good.
You know, this isn't quite along those lines. But I have participated in these reenactments of well-known trials where they take the transcript, and by doing so, it seems as if it allows it to be re-examined and take on new vantage points, and also takes on the thing of performance. So the one I participated in was put together by the Honorable Denny Chin, who sits on the Second Circuit of the U.S. Court of Appeals, who's been doing this. And he wanted to do a reenactment of the Vincent Chin trial. And Vincent Chin, if case folks don't know, most of you I think do know, was a Chinese American who was murdered by 2 white males, out-of-work auto workers in Detroit at the height of the anti-Japanese, anti-Asian hysteria. And the Honorable Denny Chin wanted to reenact this. So we did this over at Hastings. And it's interesting that the cast was made up of lawyers, local lawyers, and local judges, both retired and active. So that the event became a very interesting thing of performing a case which was already done by people who are actively involved in this particular field. And it created kind of a new way of approaching it, a new kind of way of the performers experiencing the work. And I thought it's an interesting way to crack open something, not necessarily for the future, but certainly in terms of taking the past and resurrecting it and then re-examining it, and perhaps at that moment, offering new points of view.
Any other panelists have thoughts? Okay, with that, so I am going to look here at the Q&A. So I think this is in some senses, I think this is a practical question, at least for many of the law students who may be on this, in the audience for this panel. It's a question I struggle with all the time. So one of our audience members asks, any advice on how to incorporate our creative work into our law school time? Curious as to the practical ways you all balance these very important passions in the context of law school demands. I'm gonna broaden that question just a little bit and actually just ask the panel, like, it's clear that all of you have different passions and different sort of projects and things like that. And maybe this is just going to be a question of how do you balance time between, say, two or more different things that require different ways of thinking, different communities, et cetera.
I mean, I think that art and legal scholarship can readily inform each other. I've found it a very productive and fertile sort of cross-pollination. And so I would just encourage people to do what they think is interesting. I mean, especially as a law student, you have a fair amount of freedom to do what you want. And one of the nice things about legal scholarship is it does have a certain kind of open-endedness that other scholarly disciplines don't. I mean, after all, you can post anything you want to SSRN and people will read it and think it's interesting or not, as the case may be. And there's a lot of law journals out there and you can publish pretty much anything, although I've certainly done my best to push the boundaries on what law journals are willing to publish. But, I mean, I really, what I've always found quite surprising about legal scholarship is that we're so conservative for no particular reason, right? I mean, nothing's stopping us from doing whatever we want to. And, why not just see what happens?
Couldn't agree more. I want to offer Elizabeth a chance to jump in if she has any thoughts.
Sure, thanks. I love that freeing idea that Brian just mentioned. In terms of how do I balance these things, I would say abysmally. So it's a struggle that you'll have for your lifelong, I'm sure. And being in law school and trying to figure out how to put it all together is just like, you're in the sandbox and it's just going to be that way forever. But, I think that just to kind of wrap up some of these ideas about the constraints of law and the importance of the arts, empathy is, studies show that the more you read literature, the more empathetic you become. And so apparently we're reading the NEA, National Endowment for the Arts, reported that we are reading the lowest amount of literature since they began recording this in the 1980s. And at the same time, you have the rise of the attention economy, so Facebook and Instagram and so forth. And it's interesting because a lot of these companies have these really strong innovation teams and innovation efforts to focus, and they say they will lead, with a customer-centric approach and really value empathy. But at the same time, they, I think, are lacking a really big risk-taking. Because if you really were empathetic with your users, you would say, wow, people are spending hours upon hours of their day on our platforms. and they're not devoting their attention to their work. They're not devoting their attention to their relationships. And so I would think that, that those companies have a responsibility to treat our attention in a just way, in a responsible way. Simone Weil said, attention is the rarest and purest form of generosity. And Henry James said, which I always shiver every time I say this, in sum, your life will be what you paid attention to. And then when you think about all the time you spend in the digital world, it's like, oh God, no, I don't, but it's true. And so to value your attention and understand, for the law students out there, to understand the importance of your relationship to your own attention and how you can have agency over that, is, I think, an essential human, very important thing to do. And rather than thinking about it as, balancing and juggling all these things, maybe you can think about it from a different perspective of, what is my relationship to my attention? And then the last thing I'll say is, in terms of potential limitations of the law, is just the topic of forgiveness. I think law is very concerned with justice, and there is definitely a place for justice. But I think our society right now is hurting so much, and there's not really a lot being said about forgiveness. And forgiveness is really hard work. And so trying to think about, and through empathy, hopefully you can, that helps and goes a long way with forging forgiveness. But we don't, I wish we had a Dr. Martin Luther King Jr. right now. We don't seem to have one like presently with us. Maybe somebody on this call will become that. But ideas of forgiveness, I think, sometimes are left out of law, and that's where restorative justice can come into play, but so important for our polis. So thanks.
That is such an incredible point, and I really wish that we had at least another 2 to 3 hours. I know Zoom fatigue is real, everyone, but I really wish we could continue this on for a much longer period of time. So at this point, I just want to offer it's 7:56 p.m. where I'm at right now. I want to offer a quick opportunity for the panelists if they have any remaining very brief thoughts. And then after that, I just want to have an opportunity to thank the hosts and close this out. So panelists, if you have any other brief thoughts you'd like to leave with our wonderful audience today, please feel free to pipe in.
If I can just respond, I was quite taken by what Elizabeth was saying, and if I can sort of add this whole idea of empathy versus compassion in a kind of Buddhist point of view. And that empathy is good. It allows you to see the world through the other's eyes, feel the world through the other's eyes. But compassion is taking that into consideration and then doing some kind of action to alleviate the suffering. So in a sense, it's that, you can feel empathy, but the idea of feeling compassion is to go beyond that and take action, which I think is kind of in keeping with what Elizabeth was talking about, and that it's important to have compassion.
I would add to what Phillip just said and say that you can always be an artist. Being an artist is, in my opinion, just a way of living in the world. And maybe just try to look for the medium in which you can most deeply express the art that you have to give to people.
I think I would say, since a lot of the students here tuning in are artists, lawyers, or both, I think everyone's both, even if you don't know it. Is just both careers involve a lot of rejection. I mean, if you're an artist or a playwright or any kind of artist, an actor auditioning, it's no, 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 until someday it's yes. And even after that awesome yes, you're still going to get a lot of no's. And if I had to show you every single rejection letter I've ever gotten before I got productions at major theater companies, you wouldn't have time to look at them all. It would just bore you. But that's a lot of rejection to get through. And as a lawyer, you'll lose a lot of cases. And you lose really big ones sometimes, and you just gotta keep going. And I think that's an important quality for both careers, is to not get caught up in rejection or loss.
Well, on that encouraging and deeply needed point at this time that we live in right now, I just want to thank our 4 panelists, Brian Frye, Elizabeth Kovats, Mary Kathryn Nagle, and Phillip Gotanda for joining us here. Please give a round of applause within the confines and space of your own home. I would like to thank the Berkeley Arts and Design Initiative and Berkeley Theater, Dance, and Performance Studies for helping organize this event. I would also like to thank and plug Berkeley Arts and Innovation Advocates at Berkeley Law. My colleague Alix has dropped the email address of the Arts and Innovation Advocates in the chat, aia.berkeleylaw@gmail.com. Just making sure that I got that right. Yes, aia.berkeleylaw@gmail.com. And I want to also offer finally my heartfelt thanks to all of you for joining us here today. This has been an incredible panel, a real dream come true in many senses for me. And I'm glad that all of you had an opportunity to be a part of it. So thank you very much.
And I want to offer my thanks to you, Sarang, for being such an incredible moderator for tonight's conversation.
Oh, come on. That's,
true intersection. Yeah. All right. Yeah. Let it end with a thanks to Sarang. All right.
Yeah. Thank you, Sarang.
Thank you.
Thank you all.
Thank you all.
Thanks very much.